My name is Vanessa. I'm 33, and I've spent the last 10 years working as a fiduciary financial advisor, the kind of job where people hand you documents that determine what happens to their money after they're gone, and you make sure those documents are honored to the letter, no matter how uncomfortable the letter turns out to be for the people reading it. I've sat across tables from families falling apart over inheritances more times than I can count. I never imagined I'd be sitting on the other side of one of those tables, in my own family, watching my aunt try to seize control of a trust she didn't know I had been quietly, legally, entirely in charge of for the last 4 years. She found out at a conference room table with a folder in front of her that had my signature on every page that mattered. Welcome back to Calm Drama Stories, where ordinary people face impossible family moments and walk out with their dignity intact. If you've ever had someone assume they understood your family's finances better than the woman who actually holds the paperwork, this story is for you. Drop a comment and hit subscribe, because what happened in that room is going to stay with you. Let me back up, because you need to understand my grandmother before you understand what her trust actually meant. My grandmother, Eleanor, was the kind of woman who ran a household like a small, well-managed company. She raised 3 children, my mother, my Uncle Frank, and my Aunt Carol, largely on her own after my grandfather died young, working as a bookkeeper for a regional furniture company for 31 years, saving carefully, investing conservatively, and never once in my entire childhood giving the impression that she had significant money. She drove the same sedan for 14 years. She clipped coupons out of habit long after she didn't need to. She was, by every outward appearance, a modest woman living a modest life. She was also, it turned out, worth just over $2.3 million by the time she passed, most of it in a diversified investment portfolio she'd built patiently over 4 decades, plus a paid-off house and a small collection of jewelry that had been in the family for generations. I was the one grandchild who went into finance, which is, I think, part of why my grandmother trusted me the way she did. I studied economics, got my CFP certification at 26, and spent my 20s learning exactly the kind of technical, unglamorous knowledge that most families never think they'll need until suddenly they desperately do. How trusts are structured, how fiduciary duty works, what a trustee is actually legally required to do versus what family members assume a trustee is supposed to do, which are very often not the same thing at all. 4 years ago, when my grandmother was 78 and beginning to think seriously about her estate, she called me, not my mother, not Uncle Frank, not Aunt Carol, and asked if I would sit down with her and her estate attorney to talk through how she wanted things structured. I remember that afternoon clearly. We sat in her small kitchen with legal pads and a laptop, and she told me, in her characteristically blunt way, exactly why she'd chosen me. I love all 3 of my children, she said, and I love all of you grandchildren, but I've watched Carol handle money for 60 years, and I am not confident she'll handle mine wisely once I'm not here to have opinions about it. Frank means well, but he's never managed so much as a savings account properly in his life. Your mother would try, but she'd fold the moment Carol pushed hard enough. You're the only one in this family who actually understands what a trust is supposed to do, and more importantly, you're the only one I trust to follow the document instead of following whoever cries the loudest in the room. She named me as the sole successor trustee of the Eleanor R. Whitfield Revocable Trust, effective upon her death, with full legal authority over the trust's assets, distribution schedule, and administration. The trust itself was structured deliberately and, I now understand, quite wisely. Rather than dividing the $2.3 million into 3 equal lump sums the moment she died, my grandmother had structured staged distributions. Each of her 3 children would receive a portion immediately upon her death, and the remainder would be distributed over a 10-year period with specific provisions for healthcare, education for grandchildren, and a discretionary clause giving the trustee me authority to adjust distribution timing if a beneficiary demonstrated financial instability that the trustee reasonably believed the immediate distribution would worsen rather than help. She was very specific about that last clause. I've watched Carol go through money, she told me that afternoon, with the particular weariness of a woman who'd spent decades quietly absorbing the consequences of other people's financial choices. She had a good job for years and somehow always needed help by the end of the month. I don't want her getting $800,000 in one lump sum and running through it in 18 months because nobody had the authority to slow her down. That's exactly why the trustee needs to be someone with a spine and someone who actually understands finance. That's you. I want to be honest that I didn't fully understand. At 29, sitting in that kitchen, what an enormous responsibility I was agreeing to. I understood the mechanics. I'd studied trust law. I understood fiduciary duty as an academic concept, but I didn't yet understand what it would feel like to actually hold that authority over people I'd grown up calling family, people who would eventually resent me for following the very document my grandmother had built specifically to protect them from themselves. My grandmother passed away 14 months ago, peacefully, in her sleep, at 82. I administered the funeral arrangements alongside my mother and Uncle Frank. Aunt Carol was, as she always was in family matters, present, vocal, and largely uninvolved in the actual logistics, which fell, as they usually did, to whoever in the family was quietly willing to handle them. The trust administration began exactly the way my grandmother had designed it. I retained the same estate attorney she'd worked with, filed the necessary paperwork with the court, and began the process of formally establishing myself as trustee, notifying all 3 beneficiaries in writing as required by law of the trust's terms, the distribution schedule, and their right to request an accounting at any time. My mother received her documentation with quiet acceptance, the way she receives most things. Uncle Frank asked a few clarifying questions about the timeline for his portion, satisfied with straightforward answers. Aunt Carol called me the day the notification arrived, and I remember the specific tone of her voice, warm on the surface with something harder underneath, the tone I'd later come to recognize as the opening move in what would become a much longer campaign. "Vanessa, honey, I got this letter about the trust. It's a little confusing. Can we just sit down as a family and figure out the actual numbers instead of all this legal language?" I explained patiently that the legal language was the actual and only accurate description of how the trust worked, and that I'd be happy to walk her through it directly. She seemed satisfied enough at the time, and the first distribution, an initial lump sum to each beneficiary equal to roughly 20% of their eventual total share, went out within the first 60 days without incident. The trouble started around month 5, when it came time for the first scheduled discretionary review, the point at which, per my grandmother's instructions, I was required to assess each beneficiary's financial circumstances before releasing the next scheduled portion. My mother's situation was stable. Her distribution proceeded on schedule. Uncle Frank's proceeded as well. Aunt Carol's did not, because in the 4 months since her initial distribution, she had, according to the financial disclosure the trust required beneficiaries to provide during discretionary review periods, already spent the entirety of her first distribution, nearly $180,000, and had additionally taken out a home equity line of credit against her house, listing the upcoming trust distribution as anticipated collateral to a private lender who was, I would later learn, charging her an interest rate that bordered on predatory. This was precisely the scenario my grandmother had described to me in her kitchen, almost word for word, more than a year before she died. Per the trust discretionary clause, I delayed Aunt Carol's next scheduled distribution by 6 months pending a financial counseling requirement my grandmother had specifically built into the document for exactly this circumstance. And I notified Aunt Carol of this decision, in writing, with a full explanation of the reasoning and the specific trust provision authorizing it. She did not take it well. The first call came within an hour of her receiving the letter. She was crying, then angry, then crying again, cycling through both with a speed that told me this reaction had been building for longer than the letter itself accounted for. "You're punishing me," she said. "This is my mother's money, and you're sitting there deciding I can't have it because you think you know better than me how to manage my own finances." "I'm not deciding anything based on my own opinion, Aunt Carol," I said as calmly as I could. "I'm following the exact terms Grandma wrote into the trust, specifically for a situation exactly like this one. She built in a financial counseling requirement because she was worried about precisely what's happening right now, a distribution being spent rapidly and then leveraged against future funds you haven't received yet. She would never have wanted you to hold my own inheritance hostage. She named me trustee specifically because she trusted me to do exactly this, even when it wasn't comfortable. I have the original conversation with her, and I have the document. Both say the same thing." She hung up on me. I didn't hear from her directly again for almost 3 weeks, which, in retrospect, should have told me she wasn't done. She was regrouping. What I didn't know during those 3 weeks was that Aunt Carol had begun quietly reaching out to Uncle Frank and to my mother, framing the situation not as a trust provision being properly applied, but as her niece, me, abusing a position of power to control and humiliate her. She'd also, I later learned, consulted an attorney of her own, not to challenge the validity of the trust itself, which would have been difficult given how carefully it had been drafted, but to explore whether she could challenge my capacity to serve as trustee, arguing that a family member shouldn't hold this kind of authority over other family members, and that a neutral third-party trustee, like a bank trust department, should be installed instead. I learned all of this the way you usually learn these things in families like mine, not directly, but through my mother, who called me one evening sounding exhausted in a way that had nothing to do with anything I'd done. "Carol wants to have a family meeting," my mother said. "She wants everyone there. Frank, me, you, and apparently she's bringing someone else too. She wouldn't say who." I had a strong suspicion who, and I was right. The meeting was held 2 weeks later at Uncle Frank's house at Aunt Carol's insistence on what she described as neutral ground, though I noticed, walking in, that she'd arrived early enough to have already arranged the seating so that she was positioned at the head of the dining table, with an empty chair beside her that I assumed was reserved for whoever she'd invited. That chair was filled 10 minutes after I arrived by a man in a gray suit who introduced himself as Aunt Carol's attorney. "Present," he explained, "just to help clarify some of the legal questions around the trust so we can all have an informed conversation as a family." I want to describe what I felt in that moment because I think some of you will recognize it. It wasn't fear exactly. It was the very specific cold clarity that comes from realizing that a conversation you thought was going to be emotional and difficult had actually already been escalated quietly into something closer to a legal proceeding, and that you were the only person in the room who hadn't been told that in advance. "I didn't realize this was going to involve counsel," I said, keeping my voice even. "I just wanted to make sure everyone understood their rights," Aunt Carol said, not quite meeting my eyes. "This isn't an ambush, Vanessa. It's just clarity." Her attorney opened with a prepared statement, careful and procedural, explaining that Aunt Carol had concerns about whether a family member serving as trustee created an inherent conflict of interest, and that she wished to explore collaboratively whether the family might consider petitioning the court to replace the current trustee with an independent professional fiduciary, a bank trust department, or a licensed corporate trustee to ensure, in his words, impartial administration free of family dynamics. It was a carefully constructed argument. I'll give him that. It didn't attack the validity of the trust or my grandmother's competency when she wrote it, which would have been difficult to sustain and risky to attempt. Instead, it attacked me specifically, my position as trustee, framing my family relationship to the beneficiaries, the very thing my grandmother had explicitly cited as the reason she trusted me, as a liability instead of the deliberate safeguard it was actually designed to be. Uncle Frank, to his credit, looked uncomfortable through most of this. My mother looked like she wanted to be anywhere else on earth. I let the attorney finish completely before I said anything because I've learned in 10 years of sitting across tables exactly like this one for other people's families that the worst thing you can do in a moment like this is interrupt someone who's still building their case. Let them finish, then answer with everything. "I appreciate you being direct about the concern," I said when he'd finished, "so let me be equally direct in response." I opened the folder I'd brought with me because I'd suspected from the moment my mother mentioned an unnamed guest that this meeting was going to be more formal than advertised, and I hadn't survived a decade in fiduciary finance by walking into rooms unprepared. "First," I said, "my grandmother didn't name me trustee by accident, and she didn't name me trustee without understanding exactly the concern you've just raised. I have in this folder a memo I wrote and had notarized 4 years ago, immediately after our initial planning conversation, documenting her specific reasoning for choosing a family member over a corporate trustee. She stated in that conversation that she specifically did not want a bank or an impersonal institution administering distributions because she believed, her words, that a corporate trustee would release funds mechanically on schedule regardless of a beneficiary's actual financial stability, whereas a family member with financial expertise could exercise judgment. The very thing you're describing as a conflict of interest is the exact feature she was designing for." I slid a copy of the memo across the table. Nobody reached for it immediately, but nobody looked away from it either. "Second," I continued, "I want to address the suggestion that my administration hasn't been impartial. In the 14 months since Grandma passed, I have processed identical initial distributions to all 3 beneficiaries on the same schedule with the same documentation requirements. The only distribution that has been delayed is Aunt Carol's, and it was delayed specifically because the trust's discretionary review clause, which applies equally to all 3 beneficiaries, not selectively to her, was triggered by financial disclosures she herself provided, showing that her initial distribution had been fully spent spent within 4 months and that she had taken out a home equity line of credit using her anticipated future distribution as informal collateral to a private lender. Aunt Carol's face went very still. "I'm not raising that to embarrass you," I said, turning to her directly for the first time. "I'm raising it because it's the documented reason for the delay. It's a reason the trust specifically anticipated, and it's precisely the outcome Grandma told me, in her own words, more than a year before she died, that she was afraid of." "You had no right to bring that up in front of everyone," Aunt Carol said, her voice tight. "You brought an attorney into a family meeting to argue for my removal as trustee based on an alleged conflict of interest," I said. "That requires me to explain the actual facts of the administration in front of the same people you brought your attorney in front of. I didn't choose this format. You did." Her attorney shifted in his seat slightly. "The trust's discretionary clause is one issue," he said, recovering. "But there's a broader question of whether it's appropriate for a niece to hold this kind of financial authority over an aunt, regardless of the document's language. That's a question for a probate court, not a dining room table," I said. "And I'd welcome that review, honestly, because I have 4 years of documentation. Every distribution, every discretionary decision, every piece of correspondence, all consistent with the trust's terms and with a conversation my grandmother had with me, which I documented and notarized before she died, specifically because I suspected a moment exactly like this one might eventually happen. I want to be honest about something. I hadn't notarized that memo 4 years ago out of paranoia, exactly, but out of the same instinct that had made me good at my job for a decade. The understanding that people's memories of what was agreed upon tend to soften and shift once money and disappointment enter the room, and that the only real protection for everyone involved is a clear, contemporaneous, documented record of what was actually decided and why. Third, I said, and this was the part I hadn't planned to say out loud until that exact moment, watching Aunt Carol's attorney glance toward her for guidance he clearly wasn't fully getting. I want to be transparent about something, because I think it matters more than any of the legal arguments we've made so far. I understand that being told your distribution is delayed feels like a punishment. I understand it feels personal, coming from your niece instead of an anonymous bank. But the alternative you're proposing, replacing me with a corporate trustee, would not actually help you get your money faster. A corporate trustee would review the exact same financial disclosures I already have, would see the exact same lump sum spent within 4 months and the exact same home equity line taken against future funds, and would very likely apply the same discretionary delay, except without any of the flexibility I've built in, because a bank trust department follows rigid internal risk policies, not the kind of individualized judgment Grandma specifically wanted applied to your situation. The room was quiet for a long moment. "What I am willing to do," I continued, "is exactly what the trust already provides for. If you complete the financial counseling requirement outlined in the document, which exists specifically to help beneficiaries in exactly this situation stabilize before receiving a large lump sum, your distribution resumes on the adjusted schedule, in full, with no further conditions. That offer has been available to you since the day I sent the delay letter. It still is." Aunt Carol didn't answer right away. Her attorney leaned toward her and said something quietly I didn't catch. She looked, for the first time in the entire meeting, less angry than tired. "I just don't want to be treated like a child," she finally said, quieter than anything else she'd said all evening. "I don't think Grandma was trying to treat you like a child," I said, and I meant it. "I think she was trying to protect money she spent 40 years building, from a pattern she'd watched play out for decades, in a way that still let you receive everything you're entitled to, just on a timeline that gave you a better chance of actually keeping it." Aunt Carol's attorney did not, in the end, file anything with the probate court. I suspect, reading between the lines of that meeting, that once he'd actually seen the documentation, the notarized memo, the distribution records, the trust's explicit discretionary language, he recognized that a legal challenge would be expensive, unlikely to succeed, and would surface in open court the same financial disclosures Aunt Carol clearly did not want examined any more publicly than they already had been at Uncle Frank's dining table. 3 weeks later, Aunt Carol completed the first financial counseling session the trust required. It wasn't a dramatic turnaround. These things rarely are. But her spending stabilized, she began working with the counselor to restructure the home equity debt she'd taken on, and her next distribution was released on the adjusted schedule, in full, exactly as the trust specified, with no further conditions conditions attached. We are not close in the way we might have been if none of this had happened. I don't think Aunt Carol has fully forgiven me for the meeting itself, even though I've come to believe, watching her financial situation genuinely stabilize over the following year, that the delay did exactly what my grandmother designed it to do. But we speak. She came to Thanksgiving. She thanked me once, quietly, in the kitchen while we were doing dishes, for not just giving up and handing it to the bank, which I understood from her to be as close to an apology as I was likely to get, and I accepted it as one. Here's what I learned from a folder full of paperwork and a dining room table that briefly turned into a courtroom. The people who try hardest to take authority away from you are very often the same people that authority was built specifically to protect them from. My grandmother didn't name me trustee because she trusted me more than she loved her daughter. She named me trustee because she loved her daughter enough to build a safeguard that could survive being unpopular, and because she understood, more clearly than any of us at the time, that love and financial protection sometimes have to look like refusal before they can look like anything else. I didn't win that meeting by being louder than my aunt's attorney. I won it by having 4 years of documentation that said the same thing my grandmother had said to me in her kitchen, word for word, before any of this began. That's the entire lesson, if there is one. The strongest boundary isn't the one you defend the hardest in the moment. It's the one you documented so carefully, so far in advance, that by the time someone tries to take it from you, there's nothing left to argue about. Only a folder and a signature, and the truth. If you've ever had someone assume you'd fold the moment they brought enough pressure into the room, you know exactly how it feels to open a folder instead and let the paperwork do what shouting never could. Share this with someone who needs to hear it. Drop a comment, hit subscribe, and I'll see you in the next one.